Good evening, friends. Thank you all for coming. You're all under examination pressure, starting very soon. First of all, let me wish you all the best of luck. And I'd also like to say how proud I am to be associated with the AOR Association. As Adv Raju mentioned, some of us got together in 1985 to start this association. At that time, there was great opposition to the formation of this association. We were accused of trying to divide the bar by having a subgroup of the Supreme Court Bar Association. The association has come a long way since then, and I was so happy to be taken round the offices, the new offices of the association. Now the association is such an integral part of the working of the court. One can't imagine the Supreme Court without the Scaora. But when we started, as I told you, we were considered rebels. Now this paper, Supreme Court Practice and Procedure. Before coming here, I saw on YouTube the lecture of Justice Subramaniam Prasad, because it's part of the same series and I didn't want a repetition and overlap. So I'm not going to repeat what Justice Prasad has told you. I also went back to my own lecture here in 2018 and I found something very interesting. That time also mine was the only lecture, it seems, where the judge who was to be part of the lecture excused himself. That was Justice Nageshwar Rao. And today also, I think more than one judge excused himself from this lecture. And so, I'm told the time is all mine, but I may not take the whole of 1 hour. But maybe it's something more to do with the topic than to do with me, that the judge hasn't come, because it happened in 2018 and now it's in 22. Now, all of you, I assume, are familiar with the standard textbook on the subject, which was authored by our Attorney General, Mr. Venkatramani. And so you are familiar with the division of jurisdictions, etc. So I won't mechanically repeat all those things, because I assume, especially at this advanced stage, that you are all sufficiently familiar. So I have picked out just 3 or 4 subjects on which I will speak at greater length. One is public interest litigation. Second is references under Article 143 and 317. Third is review petitions and applications in the guise of review petitions. Fourth is curative petitions. And fifth, duties of an advocate on record. So let us start with public interest litigation. As someone who has now been in this court for 46 years, I can claim to have been witness to the history of this court also for a substantial period. And so public interest litigation really started at the time when I was still a junior. And it started with under trials. Justice Bhagwati was the pioneer in encouraging public interest litigation. So there were the under trial litigations. Then there were the environmental litigations. The most prolific litigant of those days was Mr. M.C. Mehta. And you will find, when you look up the law reports, the number of judgments going by the name of MC Mehta, it's difficult to keep track. But what started in a very creative and positive way soon degenerated into many objectionable kinds of petitions being filed, frivolous petitions, petitions meant to serve political ends. And so at one stage, the court had to step in and lay down guidelines. So in Balwant Singh, we have this judgment of Balwant Singh, Justice Dalveer Bhandari's judgment. I suppose you have the citation, otherwise I'll give it to you as I scroll down the page. 2010 3 SCC page 402, where, and this is a judgment of 2010, and I think the Supreme Court rules of 2013 take note of this judgment. The court says in para 181, in order to preserve the purity and sanctity of the PIL, it has become imperative to issue the following directions. 1. The courts must encourage genuine and bona fide PIL and effectively discourage and curb the PIL filed for extraneous considerations. 2. Instead of every individual judge devising his own procedure for dealing with the public interest litigation, it would be appropriate for each High Court to properly formulate rules for encouraging the genuine PILs and discouraging the PILs filed with oblique motives. Consequently, we request that the High Courts who have not yet framed the rules should frame rules within 3 months. The Registrar General of each High Court is directed to ensure that a copy of the rules prepared by the High Court is sent to the Secretary General of this court immediately thereafter. So the Supreme Court was also supervising the framing of rules by the High Courts. The courts should prima facie verify the credentials of the petitioner before entertaining a PIL. 4. The courts should be prima facie satisfied regarding the correctness of the contents of the petition before entertaining a PIL. 5. The court should be fully satisfied that substantial public interest is involved before entertaining the petition. The courts should ensure that the petition which involves larger public interest, gravity and urgency must be given priority over other petitions. The courts, before entertaining the PIL, should ensure that the PIL is aimed at redressal of genuine public harm or public injury. The court should also ensure that there is no personal gain, private motive or oblique motive behind filing the public interest litigation. 8. The court should also ensure that the petitions filed by busybodies for extraneous and ulterior motives must be discouraged by imposing exemplary costs or by adopting similar novel methods to curb frivolous petitions and the petitions filed for extraneous considerations. This was in 2010, but I think our everyday experience shows that there has been no decline, in fact, in frivolous petitions still flooding the court. Also, the Supreme Court rules 2013, the new Supreme Court rules, specifically under Order 38, provide for a rule which addresses many of the concerns which Justice Dalveer Bhandari in his judgment had flagged. That is Order 38, Rule 12. Now, let us come to two kinds of references. One under Article 143 of the Constitution, where the President can make a reference to the Supreme Court for its advisory opinion. Now the question arose as to whether the Supreme Court is bound to answer a reference made by the President. Because under Article 143, the scope of making a reference is very wide, a question of law or of fact. So, in the Ayodhya case, way back in 92-93, long before the appeal was decided on merits in 2019, a reference was made to the Supreme Court, which included the question as to whether a temple existed at the site of the mosque. Now, the Supreme Court in Ismail Faruqi declined to answer the reference. Ismail Faruqi, para 83, maintainability of the reference in view of the fact, in the view that we have taken on the question of validity of the statute, that is the Places of Worship Act, and as a result of upholding the validity of the entire statute except section 4.3 thereof, resulting in revival of the pending suits and legal proceedings wherein the dispute between the parties has to be adjudicated, the reference made under Article 143(1) becomes superfluous and unnecessary. For this reason, it is unnecessary for us to examine the merits of the submissions made on the maintainability of this reference. We accordingly very respectfully decline to answer the reference and return the same. Very respectfully, because it is a reference by the President of India to the Supreme Court. Another kind of reference is a reference under Article 317 of the Constitution, where the question of removal of a member or chairman of a public service commission is involved. A constitutional body, whether it's the Union Public Service Commission or the State Public Service Commission. So really, though it's a constitutional provision, it is the equivalent of a departmental inquiry which has been entrusted to the Supreme Court in the case of high constitutional functionaries, that is, members of State Public Service Commissions. One of the questions which arose, therefore, because after all, the Supreme Court is being asked to conduct this kind of an inquiry, was whether before the case comes to the Supreme Court, there should be some kind of a preliminary inquiry into the conduct of the member concerned before the Supreme Court is burdened with this kind of a reference. But the Supreme Court said no. This is in a reference under Article 317, 1983, 4 SCC 358, where it was held the power of the President to make a reference to the Supreme Court under Article 317(1) is not subject to the condition precedent that he must first have the facts examined by some other body or authority. There is no justification for reading into the article a provision which is plainly not to be found in it, especially a provision in the nature of a condition precedent. But it was held in the same case that the power to record evidence can be delegated. Otherwise, can you imagine 3 judges of the Supreme Court sitting on the judicial side recording evidence in a matter of misconduct of a member of the Public Service Commission? So Supreme Court said evidence recording can be delegated, and in this case, court said the balance of convenience requires that the court should forego the advantage of seeing and hearing the witnesses, because demeanor of witnesses is important, as you know, in any trial. But Supreme Court gave up that power and said, we delegate the duty of recording the evidence to the additional district and sessions judge Delhi without conferring any power on him to decide on the admissibility or relevance of any particular piece of evidence. And then, in another case, later case, Saili Sanjeev Joshi, 2007, 11 SCC 547, the Supreme Court described in greater detail the procedure to be followed in deciding such a reference. Now, let us turn to the subject of review petitions. All of you are aware that under the Supreme Court rules, a review petition is normally decided by circulation by the same judges who heard the original matter, and where one of those judges who are party to the original decision has retired, then another judge is added, but the decision is by circulation. Lawyers routinely make applications for the review petitions to be heard in open court. But most of the time, these applications are declined. It is only Justice Nariman's judgment of 2014 which says in death sentence, the review petition should be heard in open court. So what do we lawyers do? We file applications in the nature of application for clarification, innocuous sounding applications, but the court somehow sees through these applications, and the most recent order is an order dated 17/8/2022 in Civil Appeal 8129 of 2019. This is Ghanshyam Mishra and others versus Edelweiss Asset Reconstruction Company. And here, the court says in para 8, the first para 4 and 5, having heard learned senior counsel of the parties and having perused the relevant materials placed on record, we have the considered view that the present applications are nothing else but an attempt to seek review of the judgment and order passed by this court on 13th April 2021 under the garb of a miscellaneous application. We find that there is a growing tendency of indirectly seeking review of the orders of this court by filing applications either seeking modification or clarification of the orders passed by this court. In our view, such applications are a total abuse of the process of law. The valuable time of court is spent in deciding such applications, which time would otherwise be utilized for attending litigations of the litigants who are waiting in the corridors of justice for decades together. So the applications are therefore dismissed with costs of rupees 10 lakhs each, to be paid by the applicants within 4 weeks. But still, the Supreme Court says in para 8, we however clarify that our observations are restricted to the present applications only, and they would not affect the proceedings before appropriate forums if the applicants are entitled to any remedy before any other forum in accordance with law. So the kindness of the Supreme Court, after dismissing this application and the review in the guise of an application, still says if you have a remedy in any other forum, you may avail of it. 17th August 2022. I thought this is a recent order, you should be aware. Then curative petitions. Again, just like Justice Nariman's judgment in death sentence cases, which is a judicially devised remedy that in death sentence or it must be heard in open court. Similarly, much earlier in Rupa Ashokora 2002 for SCC 38, the court devised this procedure of curative. I won't repeat the ingredients which the court says because all of you are already familiar. And so, soon after Rupa Hurra was decided, the court had occasion to deal with a writ petition which sought reconsideration of a constitution bench judgment in Narasimha Rao's case. Narasimha Rao's case, if you people will recall, is a majority judgment of 3:2, where the Supreme Court held that a member of parliament accused of taking a bribe to give a vote in parliament is protected by the immunity given by Article 1052 of the Constitution. That judgment aroused the moral conscience of many, but the Supreme Court, the majority view, took the view that we have to cast our sense of morality aside. The Constitution affords this wide protection to parliamentarians and legislators, so we have to give it its full meaning. So this was sought to be questioned in an independent writ petition, but close on the heels of Rupa Ashokara, in Centre for Public Interest Litigation, the Supreme Court on 18th July 2002, soon after Rupa Ashokara, decided not to entertain that writ petition because essentially it was a curative petition. The review had already been dismissed, and so the court said no, sorry. Now, let me come to the duties of an advocate on record. And that is also, I think, the right occasion to administer a note of caution, a word of caution to all of you who will become advocates on record. Many of you will be approached by your friends to file their petitions, either because they didn't want to become advocates on record, or they were too lazy to take the examination, or third category, those who couldn't make it. And so all of us have to oblige our friends in the profession. But that has led to very awkward situations for an individual advocate on record who has acted merely as a signing counsel. Averments in the petitions have not been checked, and often advocates on record have stayed away from the court because they felt it was not their matter, so they didn't even feel it necessary to be in the court. Their friends may not have even paid them a fee for filing the matter. Supreme Court took note of this unfortunate situation, and in Rameshwar Prasad Goel, 2014, 1 SEC 572. And the bench was presided over by Justice B.S. Chauhan, who had himself been an advocate on record in this court before he became a judge. So he knew the many things which were happening, which had happened even in his time when he was an advocate on record. And so he said that advocate on record has certain minimum duties to the court, and these have to be kept in mind while filing petitions. Where court is not working properly, or if the bar is not rendering proper assistance, it tantamounts to failure of administration of justice. So that's something which needs to be kept in mind by all of you when you do become advocates on record. And the most recent instance is a matter which was decided by a bench presided over by Justice Sanjay Kaul just 1 week back. This is SLP Civil 18820 of 22, Municipal Council Tikamgarh versus Matsya Udyog Sahkari Samiti, where the court took note of certain averments made in the special leave petition, which cast aspersions on the High Court, which the court felt were absolutely unacceptable and impermissible. So I want to read from two orders passed by the court in this case. First order was passed on 18/11/2022. We are greatly troubled by the averments contained on page 8 because of the ground set out therein, and more specifically ground B. The issue is not whether the impugned order is right or wrong, but the endeavour to scandalize the division bench of the High Court by making averments that it unduly favoured the original petitioner society and attributing judicial misconduct in recording proceedings. This is a petition filed by the Municipal Council of Tikamgarh, that is a municipality. We have little doubt that the endeavour is to scandalize the court. On our query, where is the advocate on record who has signed such a petition? The learned counsel appearing before us says that he has drafted it. Be that as it may, that is no ground for an advocate on record to pen down his signatures as a filing counsel for the same. Let contempt notice issue to Mr. Vijay Singh, Assistant Accountant in Municipal Council at Tikamgarh, who has signed the affidavit. The advocate on record, Mr. So-and-so, and the counsel who claims to have drawn the petition, namely Mr. So-and-so, as to why they should not be proceeded against for contempt and be punished in accordance with law. And then comes the second order. That poor assistant who swore the affidavit in support of the petition. This is what he says. We have perused the affidavit in reply to a suo motu contempt petition filed by Mr. Vijay Singh, Assistant Accountant, through Mr. So-and-so learned counsel, who was deposed in support of the petition. It is stated by him that his knowledge and exposure to the English language is limited considering the background from which he comes. He further averred in para 8 that insofar as pleadings relating to the imputation of motives to the High Court were concerned, though the contemner cannot plead ignorance, he was briefed by the office of Mr. So-and-so advocate, seeking to inform him that this was based on some judgment of this court and he was not in a position to question the same. So an advocate is telling the poor deponent of the affidavit that whatever I have written here is based on some judgment, so you don't have to say anything about it. Learned counsel appearing for him further states that an appropriate application will be filed seeking deletion of the objectionable paragraphs. he has submitted an unconditional apology arising from the portions found offensive by this court, which has given rise to the suo motu contempt petition. Let him file an appropriate application. An affidavit has also been filed by Mr. So-and-so advocate on record. While apologizing, he submits that it happened inadvertently. We find it a little difficult to accept the reason, as there is responsibility on an advocate on record before penning down his signatures. Mr. So-and-so has drawn the petition and it is bound in duty to have verified the complete petition before performing the task of what has been filed. This is only a learning experience for him, but for other advocates on record who may tend to pen down signatures without reading what they are filing. We thus caution him to be careful in future, looking to the responsibility of an AOR. He may file an appropriate application as the deponent in support of the petition seeks to make. So, this is, I think, important for all aspiring advocates on record. Now, unfortunately or fortunately, I am not an examiner for this paper. If I had been, I would have thrown some hints as to what you should expect. But I'm not in a position to do that. But still, as a fairly experienced examiner, I can tell you what an examiner expects. First of all, since you people now work on your laptops, I suggest that for the next few days you enroll in some handwriting classes so that you reacquire those skills, because there is nothing more irritating for a senior citizen examiner. And and just like the people who are called to give lectures here are senior citizens like myself, the examiners are also chosen from among senior citizens. And therefore, neat handwriting is a must. Second, brevity. Clear, short and crisp answers. You don't have to go into unnecessary depth as long as you are clear in your mind and you are focused in your answer. Time management is very important in writing this examination. I have found, in my experience, the first 2 or 3 questions answered very well. And it's been a delight sometimes to read the answers of some candidates. And you tell yourself, you're looking forward to giving this candidate maybe 80, maybe 85 in that paper. But then your heart sinks when you come to the 4th or 5th questions, because the poor examinee has not managed her time. And so, those 2 answers are attempted so hurriedly that all the advantage gained in the previous questions is lost because of poor time management. On the other hand, some candidates have managed their time so well that after answering, usually I think it's 5 questions, after answering 5 questions, they attempt a 6th one also. And perhaps they think that the examiner will then mark them on best of 5. That doesn't happen, at least as far as I am concerned, it has never happened. I have stopped applying my dimag after the first 5. I have not looked at the 6th answer, and I have made a note on the paper that this candidate has answered more questions than required, and therefore answer number so and so is not being evaluated. Finally, and I think I should have said this before I gave these little tips, there can be drafting questions in a practice and procedure paper also. If you look at previous question papers, you will find them. When I was an examiner, I made it a point to set one drafting question, which will not be an elaborate drafting question like your drafting paper. But wording of prayer is so important as part of practice and procedure. Now, the most common mistake which is made, I find when briefs come to me as a senior counsel, is the prayer in a stay application. Let's take a simple case of an order of transfer from zone A to zone B. Of course, courts don't normally interfere in transfer orders, that's a different matter, but that doesn't stop us from filing petitions for transfer. So a writ petition is filed before the High Court first, challenging this transfer of Mr. A from so and so zone to so and so zone. The High Court dismisses the writ petition, right? Then you come to the Supreme Court and you again ask for stay. 90% of the time, I find that the prayer is stay the judgment of the High Court. Now, when I ask the instructing advocate, what do you mean stay the judgment of the High Court? The High Court has only affirmed an order of dismissal by the writ petition. The answer I often get is the registry doesn't pass our petitions, doesn't number our petitions unless we say stay of impugned judgment. Now, let me remind you, the registry is not the examiner in this examination. So, if such a question is asked in the examination, the right prayer would be grant ad interim ex parte stay of operation of order of transfer dated so and so. Confirm the same after notice, and not stay of the judgment of the High Court. And finally, to leave some time for questions, I want to pose a question and I would want one of you to answer this question of mine. Suppose the Supreme Court issues notice in a petition limited to ground A or D, or grounds A and B of the petition, or grants leave also, special leave also, limited to ground so and so, so and so. When the matter comes up for hearing, is it open to you as counsel for the petitioner or appellant to contend that the court should consider the matter on other grounds also? Is the court completely precluded from going into the other aspects of the matter only because notice was limited or leave was granted on a limited question? That is my question, and I want one of you to answer this in the next session. Thank you all. I welcome your questions.
Sir, how many corrective petitions have been allowed till now?
Hardly any. Hardly any. Now, please watch with interest, but of course, it won't be before your examination. the Bhopal case, the Bhopal gas tragedy. The curative petition is now coming up, and the Union of India is supporting that curative petition on behalf of the gas victims. Let us see how the court, because the court seems to have taken this matter very seriously. But otherwise, in answer to your question, I really can't recall more than 2 or 3 instances.
The only purpose is delay. In that mercy petition was delayed and therefore
That's right. That's right.
was converted into.
That's right. That's right. So those are one of those rare instances.
It's rare.
Yes. Anything else, or shall I give you the answer to the question which I posed?
In that case, that court would not be precluded.
Yes.
Court would not be precluded
From
from that as notice was issued only
Yes.
on that ground.
correct answer. Do you have any authority to support your answer?
Yes.
Do you have any authority to support your answer? You have given the correct answer. You have given the correct answer.
To do complete justice, that will be the authority that court would imply.
Yes, that's right.
That would
But this question has come up before the court, so I am giving you a case. This is Balai Chand Hazra. Okay. This is an old case, decided in 1978. 1978 to SCC 559. Because the principle of this decision is when it's hearing the matter at the final stage also, the court is exercising Article 136 jurisdiction. So it can't be precluded from considering other aspects, especially because the court has power after all to review its own orders. Therefore, as long as fair notice is given to the other side, that the court will give, will hear the matter not only on the limited grounds, but on other grounds as well, as long as the other side has the opportunity to make the case on other grounds, the court has full power. It may not do so often, but the court has that power. So since this is a rare case, I think it is worth noting and citing if such an occasion arises. Thank you. I wish you all the best.